Hi, this is Keir Finlow-Bates, and today I'm talking about inventing and patenting for software engineers, although it also applies to hardware engineers. And the aim is basically to give you an idea of what inventing and patenting is about, and to let you know that pretty much anybody can actually become an inventor. So, first let's sort out what a patent actually is, because there are three, or actually four, key things that provide you with protection for intellectual property. The one that most people are familiar with is copyright. It protects art, writing, and poetry. So if you write a novel, or you take a photograph, or you make a sculpture or something like that, then copyright protects that. Trademarks protect a brand. So if you come up with a new recipe for a fizzy drink and you give it a name, then you can trademark the name to stop other people selling fizzy drink under the same name. And finally, trade secrets are an agreement between employees and companies that allow the companies to subsequently sue you if you reveal that. So trade secrets are used for things like formulas for flavored chicken or something like that. So those are the non-patent things, whereas patents actually protect ideas, or what we really think of as inventions. And ideas in this sense are ways of doing or making stuff, or an actual made thing that has a function or a use. So looking at patents, there are actually two types of patents in the United States. There's a design patent and a utility patent. And a design patent is basically saying, I've got this thing that I have made, like a mobile phone or a desk lamp, and I want to protect the design so other people can't make something that looks the same. So it's almost like copyright in a way, but it's tied to an invention or an object that has a use. Whereas a utility patent covers the rest of the inventing kind of things. So that's a process for doing something, or a new chemical that you've synthesized in a lab, that kind of stuff. So we're looking at utility patents. And then the question is, what actually does a patent get you? And the thing is that a patent is a contract between the inventors and the state. It doesn't give you a license to do something or make something. What it gives you is the right to sue other people who use your invention without paying you for it, without you agreeing to them to use it. So it gives you the right to sue and not a license to practice. And as it turns out, suing someone for breaching your patent can actually be very, very expensive, but ultimately the damages may be worth it. So when you've got some inventing going on, you have a number of parties involved. You have the inventor, who has the idea and fleshes it out and turns it into something usable. Then you have the assignee. That's going to be the person who actually owns the patent at the end. So if you're an independent inventor who's pursuing his or her own patent, then the inventor is also the assignee. Whereas if you're working for a company and they pay someone to patent, to do the legal work to get a patent based on your invention, then the company will end up being the assignee. Then you have the patent attorney. That's a lawyer who specializes in making sure that you can turn the invention into a patent. And then at the patent office, there's an examiner who actually looks at what the patent attorney submits and decides whether or not it's worthy of a patent. And then there is a fifth party way at the end, which would be infringing parties, people who subsequently use your invention without a license from you. So what can you patent? If you're going to invent something, you might as well invent something that is actually patentable. Otherwise, it's not going to be an invention according to the patent office. So an invention has to be novel. It can't have been done before. It has to be non-obvious, which means it's not just a matter of sort of Lego block style putting two things together that anybody could see. It has to be statutory, which I'll cover later. And basically, it has to be based on an idea or a concept or something inventive. And the areas that those break down into are business methods, which are ways of conducting business, processes, which are ways of doing stuff either in industry or in engineering, products, so that's things like a new can opener or a new door hinge or something like that, plants. If you manage to crossbreed plants to produce a new hybrid, you can patent it so that other people can't take your seeds and grow the same plants. And medicines. And the final thing is that it has to be not publicly disclosed. So if you go and talk down the pub to somebody about the great new thing that you've invented. It's now public. You might get a patent if people don't find out about it, but if it goes to a court case, believe me, the lawyers will probably find the guy who you were sharing a pint with, and that's it. Your patent is no longer valid. So you have to keep it secret until you've filed your patent. So what can't you patent? Non-statutory things, and that's why I'm going to explain the term that I kind of glossed over in the previous slide. Non-statutory things are things like laws of nature. So, for example, E equals mc squared can't be patented, or Newton's second law, or things like that. Some algorithms can't be patented. This starts to get a bit thorny, because if it's a complicated, new, interesting algorithm that has a use somewhere, then it may be patentable. But if it's just a clever sequence of mathematical operations, it probably can't. You can't patent naturally occurring objects. So if you crossbreed two plants to make a new one, that might be patentable. But if you happen to find a new plant in the Amazon jungle, that cannot be patented. Then things that can be done mentally or with pen and paper. So there are a lot of software patents out there where the patent office then rejects them on the basis that, yes, you're doing it with a computer, but anybody with pen and paper and enough time could do the same thing. Therefore, it's not patentable. And again, this one's a bit thorny, because anybody with a computer science degree will know that you can basically emulate a Turing machine by using a long ribbon of paper and a pen. So I'm not entirely clear what the patent office means by this. It becomes subjective. And finally, data structures cannot be patented, although a particular data structure plus a use for it that has an unexpected outcome, that can be patented. Anyway, if you're getting a patent attorney, it's best to let them worry about whether what you've submitted is patentable or not. Right. Anyway, back to the world of the inventor. And the thing about being an inventor is having the right mindset. So what you need to do is not just do stuff or think about stuff. You need to think about how you're thinking about stuff. It's kind of meta thinking in a way. So there are some questions you can ask yourself when you're working that may actually trigger you to realize that you've invented something. So the first one is, have I come up with something clever? It doesn't have to be super clever, but is there a twist to it or something that makes it a bit unusual in your mind? Then it might be an invention. Did you just copy paste it from Stack Overflow? Then it definitely is not. One thing that I find useful is when I'm inventing something, if I come up with a new idea and at the end of it I feel pleased because there's something satisfying about having come up with a way of doing something or a new concept, if I feel happy about it in this kind of satisfied way, often that means I've done something new. So for me, that is an indicator that I've invented something. And finally, sometimes the invention itself is actually really, really easy. It sort of drops out. It's a matter of finding the problem. So if you see something where the way that it's currently done is cumbersome, annoying, frustrating, or bureaucratic, and you come up with a way that bypasses some of these problems, then you may actually have invented something. And sometimes that can even trigger you to come up with the invention because you see the problem, and the framing of the problem is the hard thing, whereas coming up with a solution is actually quite easy. So, inventor's mindset 2. If it's the end of the year, you've probably already invented 10 novel things without realizing it if you're working in software development. It's a lot easier to come up with something new than you'd think. So it's worth going back over what you've done over the last year and having a look at the particular things that you thought were tricky when you first hit them, and then you had an aha moment and you solved it. And there may well be a good, valid invention lurking there. Finally, I said, is it clever? Is it clever doesn't necessarily mean, is it complicated? Because often a simple idea is actually much more powerful and much more useful than some very elaborate, complicated system. And this is particularly the case with patents, because the more complicated your system and the more specific it is, the more likely it is that somebody can come up with a workaround. And I've got a picture of shoelaces here because there's a very simple invention at either end of a shoelace, and that is the little plastic bit that stops it from fraying. Very simple concept. Somebody came up with that, and it would be a patentable invention. So you don't have to invent an artificial android that is capable of driving a car in order to get a patent. It can be as simple as a piece of plastic on the end of a shoelace. So when you've got your idea, I find the best way to then approach it is to basically do what entrepreneurs do when they're pitching to investors, which is you need a 5-second pitch. You take your idea and you summarize it so that if you were in an elevator trying to describe to somebody what you'd invented, what 1, 2, or maximally 3 sentences would you use to describe it? Preferably 1. And that's your 5-second pitch, and that should really summarize your invention, and it will eventually become probably the title of the patent application that you file. And then the second thing you do is you take your basic idea and you write this incredibly elaborate story about it, where you try to cover every possible way that your idea could be used. And don't just stick within the field that you're in. If you've got a brand new widget that's great for caravans, maybe it's also great for boats and helicopters and cars and houses and basements. Who knows? Just try and expand outwards and think, this is useful here. What other areas could it be useful for? And the more areas you can find that it applies, the more valuable your idea is probably going to be. Right, so that's the mindset number 5 thing I have there. I've got a picture of paperclip here because a thinking outside the box exercise that some of you may have done is, can you think for 100 new uses for a paperclip other than just holding 2 sheets of paper together? And when you first face that question, it's quite hard. You get stuck because you focus in on the fact that it's a paperclip. It's designed to hold paper together. When you start thinking around and you imagine the paperclip in other situations, then suddenly you go, yes, I can unfold it and I can use it as a hook to hang stuff on a rail, for example, or I can straighten it out and turn it into a lockpick, and so on and so forth. So you, instead of thinking about the object itself or the computer code itself, you can start thinking about where could I put this object or this computer code, and could it do something else very, very different but just as valuable and useful. Thinking where to use it is much better than thinking of the object itself. You get fixated otherwise. So what's the process then? Well, if you're working in a company and there's a patent attorney, you write an invention disclosure, and typically actually that takes a very short time because there's not much to fill in. You can do a brief search on the web, see if somebody else has done it, because if you type in my great new widget description and up pops a page where somebody did that 5 years ago, you don't want to be wasting people's time. However, if you're working in a company, companies generally don't like you going off and reading patents, because if you open up a patent and you look at the title and then you close it again, that could later be used in court to say, actually, this person studied this and they should have realized that their invention was buried there on paragraph 66, third sentence. On the other hand, if you're a pro se inventor, that means that you're prosecuting the invention yourself. Then you have to do your search yourself as well, probably, because you can't afford to pay for one, in which case you do have to start digging into patents. And then finally, if you're in a company or if you can afford one, you'll discuss with your patent attorney about how to take the disclosure and turn it into a patent application. Right, so when you're working with a patent attorney, I personally find them great people to work with because they have technical degrees and law degrees. So they're not focused, they're not specialists other than specialists in applying and obtaining patents. However, they're not specialists in your field, and often they don't know how to code. So if you're working with software, don't expect that they are able to write a program. But they will have a high level of education, and they tend to be on the brighter end of the scale. So I personally find them very, very good to work with. I don't think I've met a bad one yet, to be honest. And you should take the opportunity to maybe talk to them, get a bit more of an education about what patenting is about, especially if a company's paying for the attorney's time. Right, so the patent attorney, or if you're a pro se inventor, you will draw up a patent application, and a patent application has a bunch of different parts. It has an abstract. That's a maximum of 150 words describing what the invention is all about. It's a bit like the blurb on the back of a novel where it summarizes what the story is about. Then you have technical background, where the problem that your invention solves is described and other previous solutions are briefly touched upon, usually to point out where they're deficient so that you can highlight where your invention has an improvement. Then there are drawings. There are some very specific rules about what they can look like. They can't just be photocopied off the back of a napkin. And they're meant to illustrate how the invention works. And drawings in the patent world really do satisfy that old maxim that a picture is worth 1,000 words. If you can get a bunch of relevant drawings, it's much more valuable than a lot of writing. So if you have a thought of what might be a valid drawing, do submit it. Don't think, I can't be bothered. Then there's the detailed description, and that is basically something that goes through all the drawings and identifies all the parts in the drawings and explains what they are and where they might be used, and covers lots of different cases where your invention might be valid. And then finally, the bit that I put in bold are the claims. And this is the legal part, which reads a bit like a computer program. It's probably the closest I've ever seen to the English language, or if you're filing in a foreign country in that language, the closest I've seen to language, natural language, being used as a programming language. There's some very specific meanings to the terms that are used in claims, and they read very stilted in a sort of robotic manner. But basically, it's the claims that people are going to infringe if your patent is granted, and so they have to be written very, very carefully. And it's the part that the patent attorney probably spends the longest on, and the part that the examiner looks the closest at. Right, so you may find yourself in a situation where you're asked to review a patent application, or possibly a patent, to see whether it's describing your invention or whether something that you're working on infringes somebody else's patent. And patents are written in a rather strange way. Firstly, antecedents are introduced. So whenever something is talked about, you have to start off by saying a thing, and then you can talk about the thing. And this is the case even when it doesn't really make much sense. For example, you may see a sentence, a circle with a center. And as a mathematician, you think to yourself, well, a circle only has one center, so it should be the center. But in patentese, you have to write it as though a circle could potentially have a multitude of centers, and it's a particular one that we're talking about. The patent world uses the word plurality to mean several. So you will see things like a plurality of computers configured such that. You'll see the term embodiment, and that basically means an instance of your invention that's configured in a particular way. So, for example, a car, a motorbike, and a van are embodiments of petrol-powered automotive devices. And then the word comprises, that means it consists of at least. So if you say that my invention consists of A and B, in the patent world, that means that it doesn't consist of anything else, just A and B. But if you say that your invention comprises A and B, it may also have elements C, D, and E that you happen to not have mentioned at this point. And finally, words like and or don't work like they do in code. They're not as logical. Sometimes and can be read as or can be read as and often they put and/or just to make sure that you don't have any real confusion. I wouldn't get too hung up about the details unless you actually enjoy it, like I did when I first came across it, in which case, knock yourself out, go and dig into how patent terminology works. But basically, your aim is to look for mistakes in the way that your invention is presented. Has the patent attorney got the wrong end of the stick? And then you can help them correct it and correct your patent application and end up with a much better patent. So, in summary, it's a process getting patents. There are very clearly defined steps on how to do it. It is expensive if you pay for a patent attorney and a search and professional draftsman. It can be very, very cheap if you do it yourself, but then it's time consuming and there's quite a steep learning curve. But the fact is, the original idea that triggers the drafting of a patent application is something that anybody can come up with. You could have just started in a company fresh out of college. You may have worked somewhere for 30 years and never have filed an invention. The fact is, tomorrow you can go to work, come up with a new idea, and in a year or 2 or 3's time, there may be a patent out there with your name on it because of that. So I'd say go ahead, keep your eyes open, look for areas where you think you've done something novel, and then see where it goes. And that's it for now. Bye-bye.